following along, Rule 601. This is the general rule of competency. What this rule does is tell the court and everyone involved what competence a witness needs, basically the test of competency. What makes someone competent to give testimony in court? The rule is really simple. Every person is competent to be a witness, except as otherwise provided in these rules. It's a very low standard. You're really never going to come into it in terms of mock trial, but it's good to know that in federal court and so on, there's a very low standard of competency. It used to be that if you were drunk, if you were a woman, if you were a minority, you weren't competent to testify. Shut up. You weren't competent to testify. Now all that's done with, and everyone's competent to testify unless otherwise provided. Now, the second part of Rule 601 says, except as otherwise provided in these rules. What Rules 602, 603, 605, and 602, 3, and 5 do set up those exceptions. So, you can read Rule 601 to say, everyone is competent unless they're disqualified by Rule 602, 603, or 605. Are we clear on that? Alright, so 602 is everyone's favorite objection.
Could you repeat that again? Sorry.
Yeah, absolutely. You can technically read Rule 601 to say every witness is competent to testify unless they are excluded by Rule 602, 603, or 605. So the first way that you are excluded and deemed incompetent is by having a lack of personal knowledge. Everyone loves to make this objection, lack of personal knowledge. What lack of personal knowledge really means is, as the rule puts it, a witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. What does that mean? That means you actually have to know about what it is that you're talking about. Keep in mind, it's still a very low level. It doesn't say you have to be an expert, and it doesn't even say you actually have to have been there to testify to it. It's just saying you have to know, you have to personally know what it is that you're talking about. The second sentence says, evidence to prove personal knowledge may, but need not, consist of the witness's own testimony. This rule is subject to the provisions of Rule 703. Don't confuse lack of personal knowledge with speculation. Speculation is something that you could not ever know. Lack of personal knowledge means you do not know it. So object speculation, that would be proper if someone were testifying to how someone else felt or what their personal feelings of a matter were. But lacking in personal knowledge is asking what color the car was when the person you're asking wasn't there. You guys understand that? Does anyone have any question on how to distinguish personal knowledge from speculation? It's very important that everyone understand this because everyone screws it up all the time.
So essentially, personal knowledge, you can know something, but you just didn't know it at that instance. Of speculation, you can never know it because it's not like a tangible thing.
Right. Personal knowledge is something lack of personal knowledge is something you could know but don't. Speculation is something that you could try try your hardest and never could know. So let's run through a couple hypotheticals. If you're talking to a doctor and the doctor is trained in toxicology and you're asking him about ballistics, is that subject to lack of personal knowledge or speculation?
Lack of personal knowledge.
Why?
Because he could know about it, he just doesn't.
Okay. Now, what if you're asking him about toxicology, but the question is how many beads the little boy had in his hand moments before he ingested it? Keep in mind that the doctor wasn't there.
Speculation.
Why do you say that's speculation?
Because there's no way for him to know that. He would have to guess. He would not be able to tell you because he wasn't there, he didn't see it.
There's no way that he could have known that.
Well,
If he was
barring being told that or being shown that.
That's the difference between speculation and lack of personal knowledge. Speculation is there's no way you could know what was going on. No way. Be it through hearsay, be it through any other means, that's still lack of personal knowledge. True speculation is something that you could never know. And it usually goes to how people thought, what people were thinking, what people were feeling, what people's intentions were. These are things that even if that person who you were speculating upon were to tell you, you could not know it. Because it's indefinable. It's without a definition. So that's the difference between speculation and lack of personal knowledge. That was really good, by the way. All right, any questions on Rule 602? 603 is never going to be applicable to you guys. Just know that this is a common law rule that required, basically in heavily Catholic England, before we emigrated here and set up this phenomenal country. People could never be tested, so they were asked to swear on the Bible. Now, since we have the separation of church and state, we just ask that you take an oath or affirmation.
England isn't Catholic, it's Protestant.
In 1620, before the Protestant Revolution, they were Catholic.
You didn't say
That was King Henry's Church of England. Thank you very much. This is going to be posted online.
You didn't say
Rule 605, competency of judge as a witness. This is also going to be inapplicable for your purposes. Just keep in mind that this is really simple. A judge can never testify in a trial that he or she presides over. Rule 607. This is kind of a big one. This is who may impeach. This says that the credibility of a witness may be attacked by any party, including the party calling the witness. Someone tell me what this allows you to do.
Prove the witness wrong.
That is a correct answer. That isn't the correct answer I was thinking of, but that is a correct answer.
If your own witness says something inconsistent and you know that the crossing attorney is going to beat them up over it, you can just kind of let it out then.
Yeah, that's another correct answer, not the one I was looking for, though.
If there's some credibility issue that's going to come out on cross, you can bring it out on direct.
That's kind of the same thing she said. You guys know what calling a hostile witness is? When you call a hostile witness in mock trial, it scores you big points, if done correctly. Unless it wasn't done correctly in your scenario.
Unless it's
If done with the right amount of class and precision, calling a hostile witness is very effective. Rule 607 says that even if you're calling the witness, you can call them as a hostile witness. Florida judges and judges most of the guys and women that you encounter as judges in your competitions are not going to understand what it is. You're never going to have to say, I'm calling a hostile witness. What you're going to do is ask them a number of questions and exhibit some sort of hostility toward, have the witness exhibit some sort of hostility towards you as the directing attorney, such that it becomes impossible for them to be cooperative with you. The advantage is what is the effect that this has. This now allows you to cross-examine that witness on direct examination. It's an incredibly creative technique. Like I said, it's very technical. If done correctly, you score big points. If done poorly, you probably lose the round. So, yeah. So my suggestion is if you're going to do it, make sure you plan ahead. Don't just do it on the fly. The point behind this rule is that in England, and by the way, the reason why I keep giving you guys the background to the rule is because to truly understand the rules, you have to understand where they came from. It's a long, arduous process. Some of you probably don't care what it is that I have to say about the history of the rule, but it's very important. It's your own problem if you don't understand it. Rule 607. In England, there was a thing called a voucher rule. A voucher rule said that attorneys, and then barristers and solicitors, would vouch for the witnesses that they called. They put their reputation on the line. And it makes sense that if you're putting your reputation on the line for someone, you can't turn around and impeach their credibility. So if I call A to the stand, and before this trial started, A said to me, yeah, I'm going to say this, this, and this, and then they get on the stand, they say that, that, and that, I have no court. I have no recourse. I'm up a river without a paddle. Rule 607 flips that and says, now you can do whatever you want. Anyone can be impeached, even by the party calling the witness, which leads us to those other 2 points that you guys brought up, that you can impeach the credibility of your own witness. If they make contradictory statements, you can clarify them. That's another issue. But that's really 607. Anyone have any question on 602, 3, 5, and 7? Awesome. All right. Rule 608. Evidence of character and conduct of a witness. Someone tell me what Rule 404 does. I can tell that a lot of you were paying attention last week. Rule 404 is the character rule. Remember? Evidence of a person's character or trait of character is admissible, but not to show action in conformity therewith, but may be admissible for other purposes such as motive, intent, absence of mistake, identity, something else, and then something else, opportunity, plan, and knowledge, and then also habit and routine practice. That rule in subsection A, I believe, sends you to other rules. You guys remember that? This is the first of the other rules that 404 refers you to.
404C?
There is no C. It's 404A and B.
A, B.
It's going to be 404A1, I think. It's going to be 404A sub 1 or sub 2. The point is that Rule 404 is broken down into the character of a witness, character of the accused, and character of the victim. Character of the witness, and the character of the witness is the part that sends you to other rules. Now, it makes sense that it refers you to the 600 rules because the title of Article 6 is, of course, they don't put it on here. The title of Article 6 is witness testimony. So Rule 404 sends you to the 600s, which concern themselves with witness testimony. So in the context of understanding Rule 608, keep in mind that you have to keep Rule 404, subsection A1 or 2, don't quote me on that, in mind. Because this is only understood in the context of character evidence. Now, on the first point of Rule 608, what are the kinds of character evidence? There are 3 ways that you can introduce character evidence. Someone tell me what they are. Remember, there's a whole timing issue with them. Wow.
Don't you have to do it on direct? If you don't do it on direct, they can't do it on cross.
That's part of it. You're a step ahead.
Opinion, reputation, specific instances of conduct.
Yes, there are 3 kinds of character evidence, 3 and only 3 ways that you can introduce the character of someone. Through opinion testimony, through reputation testimony, and through evidence of specific instances of conduct. Now, Marcus, what's the timeline?
You have to do it on your direct.
Be more specific. You have to do what on whose direct?
You can only introduce characterizations of your direct on your witness. And if you don't do that, then they can't do it on their cross, right?
Not quite. You're on the right track, but not quite. Evidence of reputation and opinion are the only forms of character evidence admissible on the initial direct examination. I'll say that again. On direct examination, you cannot talk about specific instances of conduct. However, on cross-examination, the floodgates are opened, and you can discuss either reputation, opinion, and or specific instances of conduct. That scope remains broad for the following redirect examination. My God, this sounds awful and boring. All right.